Most of our work is internal investigations and regulatory inquiries or responses. We first started using eDiscovery tools and platforms as the amount of data that we had in our digital investigations just grew exponentially. So in about 2008, I traveled to New York to visit Legal Tech to see if these eDiscovery platforms could assist in our digital forensic investigations. Because at that point in time, the forensic tools allowed us to conduct rather simple searches, and then we would just hand the data over and never hear back from the client. So we had a matter in Malaysia for a Japanese client, and so this is going back 7 years. We ran some search terms and they had 8 gig of documents to go through, which today is still a fair amount to go through, but back then they didn't have any actual review platforms. So I spent some time in New York and we adopted some platforms. We have a few here at iAnalysis, depending on the type of matter, the type of client, whether they're here in Singapore or Hong Kong, or maybe they're overseas United States. And a year later, Singapore issued the first rules on eDiscovery in Asia. So we were already providing such a service. So we really saw a takeoff of eDiscovery matters, and we were involved in some of the very early ones. The first reported matter, which is the Deutsche Bank matter. So we worked on that one. We've worked on a number of those over the years. And because we are a boutique firm, this is what we do. We're a boutique company. That's all we do. People came to us because we already had the platform in place. We'd already had, the track record. But one of the challenges that we face is that when people talk about eDiscovery, they think it's only about litigation. And it's kind of become a dirty word, so to speak. So we don't talk about eDiscovery. We tend to talk about document review. Say, for example, you're in an arbitration, and you're discussing, the review of documents. Under some rules, there is discovery, there is disclosure. But what I heard for many years from arbitration lawyers that, eDiscovery, that's for litigation. We do arbitration. Then another conversation I had with clients said, I need to respond to the SEC, I need to respond to whichever regulator, and it's not litigation. But at the end of the day, what people need to understand is that what eDiscovery platforms do for you is that they streamline the review process. They allow you to reduce the vast volume of data and respond to a regulator in time, to respond to your court-imposed deadline, and in an arbitration, to actually find those key documents. So I made the argument that actually in arbitration, these tools are more important because you're going to be reliant on those few key documents. You don't want to be in the position where, let's say, the other party has some documents. Maybe it's a former employee, for example, which is what we see a lot. So eDiscovery, yes, we use it because people know the term, but we tend to talk about document review.